Good morning and welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Richard Orfinger, and I'm joined on the panel this morning by Judge Meredith Sasso and our Associate Judge Donna McIntosh, who we welcome to the court today. Can everybody hear me okay?
Yes.
Great. This is being recorded and broadcast on YouTube, and both sides have 20 minutes. If the appellant would like to reserve something other than 5 minutes, let us know. The clock is preset for 5 minutes. Can everybody see the clock okay? All right. When the clock starts flashing yellow, you'll be into your rebuttal time. So if you would like to save something other than 5 minutes, let us know. First case we have this morning is Joshua Touchton versus the state. So Ms. Reese, if you would unmute your mic, you may proceed. Good morning.
Good morning, Your Honor. May it please the court, counsel. My name is Rachel Reese, and I represent the appellant, Joshua Touchton, in this matter. I would be requesting the standard 5 minutes of time for rebuttal. This is an appeal from the denial of Mr. Touchton's motion for post-conviction relief. I would like to focus my argument today on two of the sub-issues from point one of our briefs. First, whether Mr. Touchton's attorney was ineffective for failing to present testimony of a witness named Marcus Sodto at trial, and second, whether counsel was ineffective for failing to present evidence of an alternative suspect, Theodore Vasquez, through GPS records that were available to counsel. Mr. Touchton was originally charged and convicted of one count of first-degree premeditated murder after the victim in his case, Michael Hawkins, was shot inside of his vehicle. The state's theory of the case from day one was that Mr. Touchton was hired as a hitman to kill Mr. Hawkins by Theodore Vasquez, and Mr. Touchton physically pulled the trigger, completing that task. The state offered testimony from two main witnesses who testified to being with Mr. Touchton on the night of the shooting, John Velez-Benabe and Jeffrey Hicks. Based on their testimony, they both alleged that themselves and Mr. Touchton were the only individuals involved, and that Mr. Touchton was the only person who possessed a firearm, and later confessed to them that he had shot Mr. Hawkins. And as a result of their testimony and other evidence that was presented, the jury made specific findings that Mr. Touchton possessed a firearm, discharged the firearm, and was guilty of shooting Mr. Hawkins and killing him. At the evidentiary hearing before the trial court, it was revealed that trial counsel knew there was much more to the story than what had been exposed and told to the jury. Specifically, Theodore Vasquez, the man who was alleged to have hired Mr. Touchton to be the hitman, was more involved than the evidence led on, and counsel was aware of this and had evidence from both a witness and GPS records that would have supported that. However, none of that evidence was presented at trial, and it's our position that had this evidence been presented, it would have raised doubt in the state's entire theory of prosecution and pointed the blame on somebody else other than Mr. Touchton, raising reasonable doubt and resulting in acquittal for him.
Doesn't the record reflect that trial counsel did know of the evidence, though, of the existence of the evidence?
Yes, Your Honor, he did. And he admitted that at the hearing. He admitted that he was aware. He had listed first Mr. Sodto. He had listed him as a witness on their defense witness list, had brought him back from prison, so he was aware of that. And then as for the GPS records, counsel also admitted that he was aware of that, had reviewed them prior to the trial, and had considered both of those pieces of evidence. Now,
so what of his testimony or other evidence would you point to as your strongest argument that he was ineffective for failing to submit that evidence?
So I think that both of the claims are independently strong, but they both kind of relate around the same topic, because obviously this witness, Marcus Sodto, and the GPS records, both of them would have created this additional reasonable doubt in another suspect other than Mr. Touchton, and that's Theodore Vasquez, who was a very central part to this case, who was never really explored or discussed at trial, except for a few mentions by witnesses that that's how everyone met because he owned a barber shop where they all worked, and that this individual, Mr. Vasquez, was also the person who ultimately hired Mr. Touchton to be the hitman for this individual. So as it relates to Mr. Sodto, he was a witness that obviously had been listed as a defense witness, and at the evidentiary hearing, trial counsel again admitted that he was aware of this testimony that he was going to be giving. Mr. Sodto had met one of the state's main witnesses, Justin Hicks, at the county jail. And during his conversations with him, Mr. Hicks had divulged that he was going to be essentially committing perjury against Mr. Touchton in order to save himself. He specifically went over the fact that he was involved in this more of a master plan that had been put together in order to have a fall guy, the fall guy being Mr. Touchton if the robbery had gone south. And if he did not testify against Mr. Touchton in this way, then his family would be threatened. And obviously he was facing a very lengthy prison sentence as well if he did not kind of pass the buck and put the blame on Mr. Touchton. The fourth person who was part of this plan again was Mr. Vasquez. Mr. Vasquez had threatened Mr. Hicks's family, and Mr. Sodto became aware of that information. When trial counsel was asked at the evidentiary hearing about why Mr. Sodto was not presented as a witness, counsel could not recall an exact reason. However, he did state that the defense's theory at trial, their theory of innocence or their theory of defense, was twofold. Number one, that the state had misidentified Mr. Touchton as the actual shooter. And two, that law enforcement had persuaded the witnesses to testify in a manner that would match up with other testimony and evidence being presented in the case. And one of the ways that counsel tried to present evidence in support of that theory was by showing the jury that the state's two main witnesses, Mr. Hicks and Mr. Velez-Benaib, both had a motive to lie. They were trying to get the lowest prison sentence possible. They'd been facing upwards 50 years to life and had received lower sentences as a result of testifying against Mr. Touchton. And any reasonable counsel that became aware of this witness, Mr. Sodto, who had evidence that would have further offered evidence to prove this theory of defense, that these witnesses were lying for some other reason and this was not the truth, any reasonable counsel would have called Mr. Sodto as a witness. And again, that would have supported the underlying.
Do you agree that that testimony from Mr. Sodto would have been cumulative in the sense that other witnesses acknowledged that they were receiving deals in exchange for their testimony?
I think it would. I don't think that it would have been cumulative as to that aspect, because it was not just about for them receiving deals or receiving a benefit for testifying. I think that Mr. Sodto's testimony would have added more to the impeachment, to the fact that he could unequivocally say that he heard one of them admit that they were lying, that they were going into court to testify against Mr. Touchton, knowing that they were not going to be telling the jury the truth. And I think that adds a whole nother facet to the argument, is not only are they biased because they want to have personal benefits by testifying, but there's proof now that they are actually lying about what happened. And the importance of that is that these two main witnesses were the only two individuals who alleged to have been with Mr. Touchton around the exact time of the murder, who could actually put him at the scene, and then his allegations that his confessions that he had allegedly made to them afterwards. So this type of testimony would have called all of that into question, which is why it was so important.
And when you take that and sorry, go ahead, Judge McIntosh.
Oh, thank you. But Mr. Sodto's testimony would have only impeached Mr. Hicks if the jury believed the testimony, correct?
Yes, Your Honor. However, in impeaching Mr. Hicks, it also would have impeached Mr. Velez-Benaib, because number one, obviously their testimony was so similar, which is why counsel argued that law enforcement had not coached them necessarily, but their stories had changed over time to really become the same story. And if Mr. Hicks's testimony was impeached, then arguably so would Mr. Velez-Benaib, because they're both telling the same story. And now we have a witness coming forward that is explaining why they're giving this story when that's not actually what happened. So I think that it would have impeached both of them.
Okay, but then we have the finding by the lower court that Mr. Sodto's testimony was not credible. So how would a reasonable jury find Mr. Sodto's testimony credible?
And Your Honor, our position on that is that the trial court did find that Mr. Sodto was incredible, but our position on that is that that was an improper finding for a couple of reasons. Number one, the only appropriate finding on credibility would have been whether a jury could have believed him and not whether the actual trial court believed him. And that was in a decision out of the Second District, Tyson versus State. And in that case, the court talked about the task of the trial judge when entertaining the issue of ineffective counsel for calling a witness. And the court found that the task of the trial judge is not to examine whether he or she believes the evidence presented at the post-conviction hearing, rather than the contradictory evidence presented at trial. Instead, the judge must determine whether the nature of the evidence at the post-conviction level is such that a reasonable jury may have believed it. And our position is that the court didn't make a finding that a reasonable jury wouldn't have believed Mr. Sodto. The only finding that was made was that Mr. Sodto was incredible in the court's opinion. And it's our position that that's incorrect. The correct standard would be whether Mr. Sodto, based on the other evidence that came in at trial, whether or not a jury would have believed him in light of that testimony. And our position is that they would have. His testimony lines up with the theory of defense that was presented. And it makes sense that this random individual, Mr. Vasquez, who was never charged and is mentioned briefly, but is not made the center, it would make sense that he had more to do with this than what was actually revealed.
Would you agree that a trial judge would make a finding whether or not a reasonable jury would believe something based upon what that trial judge believes?
I do believe that obviously that would be the assumption, the inference that by a judge finding that this person is incredible, that they're also finding that a jury would not find them credible. However, I think that the way that the court found in this specific case does not allude to that. And I think that it's more of the court did not believe Mr. Sodto for reasons, again, which we are submitting were improper and erroneous, because based on the record, his testimony was very clear and very succinct and to the point. And there was no other evidence that conflicted with his presented at the evidentiary hearing that would even call his testimony into question. So our position is still that his credibility, the court's finding that he was incredible, should not be something that should be given deference in this situation. As for the issue on if Mr. Sodto had been presented, it's our position that he would have created a difference in the outcome of the case. And what's important for this point, and I always sort of note this, is that under Strickland, the showing is that there's a reasonable probability that the results of this case would have been different if counsel had acted differently. And when that's broken down, that literally means it is more likely than not that the jury would have found reasonable doubt. And Mr. Sodto's testimony taken at face value does not necessarily show that Mr. Touchton was innocent of everything, but it does show.
This wasn't a case that turned on the credibility of a single witness, though. There was DNA evidence on the victim's vehicle, on the blunt. There was cell phone evidence putting Appellant in the vicinity of the victim at the time of the shooting. So how on this record can you say it's clear that this would create a reasonable doubt in the mind of jurors in light of that other evidence that does not hinge on witness credibility?
Absolutely, Judge. And my response to that would be all of those things are explainable. There was never Mr. Touchton never denied that he had been friendly with Mr. Hawkins or had been involved with him. The fingerprint on the vehicle was on the outside of the vehicle. There was nothing actually inside the car except for the blunt, which was a mixture of DNA between himself and Mr. Hawkins, which again, counsel at trial explained that Mr. Hawkins and Mr. Touchton were friendly. They had hung out before. So those sort of things were explainable. As to the cell phone records, again, the only people that tied Mr. Touchton to that cell phone, because it was not registered in his name, was the testimony of Mr. Hicks and Mr. Vanez. So
similarly, wouldn't adverse testimony, I mean, it explainable and was explained in the sense that these witnesses' testimony are motivated by their self-interest.
Correct. And I think that's, again, they were already impeached to that extent, that it was already revealed to the jury that they had a self-interest in this. But I think that Mr. Sodto's testimony rises to another level, and it explains it is one thing to tell a jury that a witness is doing this to save themselves, but it's another reason to explain to the jury that they heard one of these witnesses say, I'm doing this because my family has been threatened and because I am doing this for my self-benefit. The witness is obviously they all denied that they were doing this for their benefit. They all denied that this was why they were testifying. They testified that this was the truth. And this testimony would have been additional evidence that would have actually supported the impeachment per se. And it's important, again, because this would have provided doubt as to Mr. Touchton's involvement. It would have provided doubt as to what he knew was going to happen, doubt that he was a trigger man, doubt that Mr. Hicks was truthful, and doubt that Mr. Velez-Benet was truthful. And our position is that based on that, the jury would have ultimately returned with an acquittal based on the way that the testimony and the evidence was presented at the trial. And that's what this court is supposed to review. And the trial court in this case found that Mr. Touchton did not prove that he was innocent. But again, our position is that's the improper standard for the court to use. It's supposed to look at whether or not there's a reasonable probability that the outcome of the case would have been different, which our position is that it would be. The second issue, and I'll just briefly touch on this because I see my time is about to go into my rebuttal, is that Mr. Touchton argued that counsel was ineffective for not introducing the GPS records that established Mr. Vasquez was within a half mile of the murder at the time of around the time of the murder. And these records were important for several reasons, but most importantly, because they would have provided the jury with evidence that a vehicle owned by the person who had allegedly hired Mr. Touchton was actually at the location of the murder, which again raises the inference and the argument that counsel could have made that Mr. Touchton was simply the fall man. He was not the actual shooter. He was the person that Mr. Vasquez hand selected to be the fall guy while Mr. Vasquez actually committed this crime. Again, Mr. Vasquez already had a motive to kill Mr. Hawkins, which is why the state argued he had hired Mr. Touchton. It all would have lined up perfectly had these records been introduced, but instead,
excuse me, did the GPS evidence show the car was at the scene of the crime or within half a mile?
Your Honor, within half a mile.
Okay.
And obviously, like cell phone records, there's a lot of things that could have been argued with the GPS records about accuracy, things like that. But the overall argument is that it would have shown the jury that there was someone else close by and that person was the actual shooter and not Mr. Touchton. And I see that
one last question. Excuse me
Yes,
for
Your Honor.
interrupting. I'm sorry. Are you abandoning your argument regarding Ms. Rosado?
I am not, Your Honor. I'm just trying to focus on these two arguments as I think that they are the most critical and the most important. And I think that they highlight counsel's ineffectiveness the most and show that if these two things had been presented, that I think that Mr. Touchton's case would have been resolved differently. And I see that I have gone into my rebuttal. I will save the remaining 3 minutes and 44 seconds. Thank you.
Thank you, counsel.
Yeah.
Davenport.
May it please the court, my name is Chris Davenport and I represent the state of Florida. Let me just read from the order. The trial court says, I do not find Mr. Sodto to be credible. He's a convicted felon serving 22-year sentence. The court said, first, he was difficult to understand and frequently used street slang, which he did not adequately explain. Furthermore, he did not provide any sort of detail with regard to exactly what crime Mr. Hicks was supposedly discussing with him. And his alleged plan to blame the defendant did not establish the defendant was innocent of any involvement in the crimes charged. Whether he was a shooter or not, he was still there. He was still part of the planning, which is what he told his attorney. He's still liable for that, even if somehow Vasquez paid him $15,000 to not actually do the shooting, which is a pretty hard theory to prove to a jury. He was still there. When you look at Sodto's testimony, he said that there was a robbery, an extra person showed up at the robbery, and they decided to make that guy the fall guy. Assuming that was true, it doesn't fit with the story the defendant told the police. He didn't say, gee, I was at this scene and all of a sudden it turned into a robbery and murder, so I got out of there. First, he said I was never with the victim. Then when they told him about the cell phone records, he eventually said, oh yeah, I was with the victim. But he never had this robbery story. So it's not like this would have all fit cleanly together with their theory of defense. Counsel said that he was aware of this well, he didn't remember this specific witness. Clearly he was aware of him. He was listed on the witness list and he called over to the jail. Counsel did investigate him, Counsel said he considered trying to put the blame on the Vasquez and decided that that wouldn't really be a helpful thing because the defendant said they were involved in it together. And he didn't want to put more focus on the guy that the defendant said he was working with to murder the victim. No reasonable counsel would have made that decision is the standard that they have to meet, and they just can't meet it here. I would submit that the credibility finding is exactly what the court is called on to do. He didn't compare it with new witnesses called by the state to reinforce the defendant's guilt like they did in Tyson. He looked at it and he was evaluating deficient performance and prejudice. What he's supposed to look at, according to Tyson, is whether a jury would have believed it. And that's obviously a credibility finding to be made by the judge at the hearing. He saw the witness. He saw how he testified. He evaluated his credibility. I would also note that there's a third person here that defense counsel didn't mention, Mr. Freeman, who was basically a jailhouse snitch. And had remarkable detail about what happened in this case, that he said the defendant told him all about it. He knew where the victim was shot. He knew how it all happened. And it jived pretty darn well with the other witnesses who were actually there. Defense counsel made the decision to attack that credibility by saying he's a jailhouse snitch. Those guys make up stories about what they hear from other people. I would submit that argument is lessened considerably if you're relying on a jailhouse snitch who is going to say the opposite about Mr. Hicks. So I think it's a reasonable strategical decision. He obviously investigated this witness. He's a 28-year lawyer. This was not his first case. He made some significant arguments in the face of overwhelming evidence, not just these witnesses, but physical evidence that tied the defendant to the victim at the time of the murder. His phones were there with him all night, and we have multiple non-deal making witnesses who saw the defendant with the victim at the bar that night. He went to the victim's house. People who were not implicated in this crime said they left together to go do a robbery on a grow house, which is what the defendant told Mr. Freeman was the story. So all of the evidence fit together very neatly here, and counsel did an admirable job attacking it as best he could. I think the trial court's finding that this would not have made a difference, calling another jailhouse snitch whose testimony frankly didn't make any sense and really didn't clear him of anything. That he did not want to call further attention to Vasquez since they were working together. I would submit that that's a reasonable decision by counsel, and his performance was fine under the Sixth Amendment. It was certainly not so deficient that he wasn't functioning as a counsel under the Sixth Amendment, which is what they have to prove, and certainly not prejudicial considering the lack of credibility of this witness and what he actually said that did not make sense in the context of what the defendant had told police. The defendant said, I wasn't with him. Oh, then I was with him, but I didn't actually do anything. I left before anything happened. That was fine, but that's a lot different from what Hicks supposedly told Sodto, that he was accidentally there, so they were going to blame him. Again, you're just undermining what the defendant told police versus the defense they chose actually fit the evidence if the jury chose to believe that none of these witnesses were credible, which they obviously didn't. They obviously believed them. So we would submit the court's finding is fully supported by the record. And unless the court has questions, we would ask you to affirm. Thank you.
Thank you, Davenport. All right, Ms. Reese.
Thank you, Your Honor. A few brief points. First, as to the credibility of Mr. Sodto, there were two things mainly that the trial court found that made him incredible. Number one, that he was a convicted felon, and number two, that he spoke in slang. It is our position that if we're looking at this in context of whether a jury would have believed him, every witness that the state called as a layperson was a convicted felon. A lot of them maybe spoke in slang. Their words were not the same as they were, obviously law enforcement or somebody else that's a professional. They are from a different area of the town. They all speak that same kind of language. And again, as we wrote in our briefs, The trial court had ample opportunity, if the court was unsure about a question, to question this witness further, and the court chose not to. So to find that a jury would not believe him, I don't believe is supported by the record. Second, the issue about whether or not, counsel did not want to highlight the fact that Mr. Touchton and Mr. Vasquez were working together. It's our position that that is not the type of argument that would have been made. The argument would have been made that there's evidence that someone else was involved. The state was not going to be prepared to introduce any evidence that Mr. Touchton and Mr. Vasquez were somehow involved together, because all of their witnesses denied that anybody else was ever even present. So to say now that the state would have been able to argue this alternative theory, I think is not supported by the record. And we're supposed to look at what the testimony at trial was. And that is that Mr. Touchton was the shooter. Trial counsel admitted that there was nothing in the record that ever placed the gun in someone else's hand. There was never the argument that anybody else other than Mr. Touchton was the shooter. So if there was evidence that someone else came in and was possibly an alternative suspect, that is reasonable doubt. And the state would not have been able to argue that Mr. Touchton was the principal, which was one of the reasons why counsel said he did not want to introduce the GPS records. And our position is that that was an unreasonable strategic reason to fail to introduce very important records that could have ultimately acquitted your client, because again, the state could have only asked for Mr. Touchton to be found guilty of as a principal if the jury could be instructed on that, and there was no evidence that Mr. Touchton was not the shooter at trial. So to find now that somehow the evidence could have said otherwise would basically mean that the state would have to admit that their two main witnesses lied about what they knew and what happened, which is our position. The record does not support that would have happened. And as to both of these issues, again, the evidence did come come down to the credibility of these, as the state said, three witnesses. Mr. Freeman had been working with law enforcement for 10 years. He was a known confidential informant. How he got that information, obviously, as Mr. Sodto points out, that information was being freely discussed in jail. That's another argument that counsel could have made. As for the other two witnesses, the credibility of their testimony was critical to the state's case. And that's why we cited to the Fletcher case in our briefs, because in that case, again, it came down to whether or not the witnesses would have been able to impeach the main witnesses. And in this situation, the testimony of Mr. Sodto and the GPS records would have impeached the state's main witnesses and provided the jury with reasonable doubt. And it is our position, based on that, the trial counsel was deficient and that Mr. Touchton did prove that he was prejudiced as a result. And we would ask the court to find that the trial court erred and reverse this case and remand it with instructions to conduct a new trial for Mr. Touchton. Thank you.
Thank you, counsel. We appreciate your arguments, and we will be in recess until our next case at 10 o'clock this morning.